So this is the second of our MiCA series. Today we'll be covering issuances. Now, the MiCA series individual episodes are run on the long side, but there's a lot to cover. I hope the content more than makes up for it. So I'm going to be covering, just before we begin, a little bit about the U.S. in a way that I didn't cover during the episode. I think it would be helpful to sort of get a sense of the U.S. or think about the U.S. as we, talk about issuances in the EU. So the disclosure regime for registered securities is largely incompatible with digital asset entity structures, and putting aside whether they're sufficiently decentralized or not. Disclosure regimes contemplate highly centralized structures, shareholders, directors, C-suite management structures. If you are a lawyer advising somebody on a mini public or a Reg A plus, or a public S1 filing, you got to make sure that there's proper corporate forms, governance, supporting infrastructure. You got to look at the roles and where the fiduciary duties are placed. It doesn't align with the decentralized structures that projects have, and putting aside this notion of even sufficient decentralization that we talked about in previous episodes under the Hinman test. The framework for qualifying financial statements with auditors forces pigeonholing, reframing of various balance sheet, income statements, the notes thereto. It's incompatible with digital asset projects, and it requires supporting infrastructures, which forces centralization and intermediation, which is just sort of counterintuitive to what a decentralized protocol is generally trying to accomplish. So furthermore, because the registration has to be filed with the SEC and every significant update or change needs to go through an approval process, it's challenging for projects to quote unquote launch, measure, and iterate their projects. And this is actually what this quote is what the Props founder noted last year when they closed their Reg A+ props protocol due to those reasons. Disclosures align with the SEC's disclosure and approval standards, and they also have to use plain English, which doesn't necessarily comport with the technology for a lot of these projects. When you consider that these have to be approved by the staff, you run the risk that there's slippage between what was said and what the technology does, and there are legal ramifications with that. So Blockstack, for example, which later became Hero, took 9 months to get qualified, and then 2 years or so, roughly they were in the whole thing for about 2 years, and then they decided, we're no longer a security, we no longer need to be registered, and we're going to be decentralized. But can you imagine the board, which is, you're in a structure that forces the centralization, and you have to make a determination or you're trying to make a determination that you're decentralized. It's sort of like counter forces, just a sort of a bizarre scenario. And we talked about this with Julia Guseva on a prior podcast. Now, we have different initiatives in the U.S. in 2021. There was Hester Peirce's, Commissioner Hester Peirce's for SEC, proposed a safe harbor exemption in 2022 last year. There was obviously the Loomis-Gillibrand bill, which I'll talk about in a second. Also, Lexpunk published Reg X, which I actually like because it tries to address disclosure shortfalls head on, and it creates a happier medium. It's more compatible with how decentralized projects actually operate, in the hope that this sort of stops those issues. But the Responsible Financial Innovation Act had a sensible approach of constructing a disclosure regime, meeting the project where it was, and endeavoring, versus trying to force the incompatible. The problem with a lot of these legislations, and this is something we're going to be talking about in a subsequent issue, a subsequent episode, is just where they stand in the approval process in committees and Congress or what have you. There's a lot of bills floating around, a lot of ideas. It just doesn't seem like there's the momentum. Hopefully, maybe there's something that gets passed this year. Whether disclosure regime is part of it remains to be seen. So with that backdrop, as I noted, this is the second in our series on MiCA. The next one will be on crypto asset service providers. So our esteemed panelists today, similar to last time's with one addition, Alexandru Stănescu, partner of SLV Legal in Romania, Alireza Ciudat, partner of Enerton in Germany, Francisco Patti, professor of private law at the University of Bocconi, Jonathan Galea, chief executive officer of BCAS Solutions, which is an advisory firm. Marina Markozek is the co-founder and executive director of the European Crypto Initiative, and William O'Rourke is a co-founder and partner of ORWL Avocats in France. So with that, I'm going to kick it off to the panel. Hope you enjoy it. Welcome to The Encrypted Economy, a podcast exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel, and your host. Join me on this journey, exploring the reach of these transformative technologies. So excited to have to bring you the second part of our panel discussions on MiCA. And I have the same group assembled as in part one. And today we hope to cover in greater depth issuances and CASPs and just a lot of in between on that. Certainly very exciting areas to cover. Now, last panel episode, we covered the scope of MiCA and also addressed the various asset classes, asset reference tokens, utility tokens, e-money tokens, and touching on stable coins and algorithmic stable coins. But on this one, we're going to lead off really covering the role of the issuer and issuances. I have the same panelists who we will introduce from last time, and we also have Alireza Siadit from Enerton in Germany. But I'll let him introduce himself as we sort of go around before we start the discussion. So I guess maybe we'll start off with you, Alireza.
Great. Yes. Thank you for having me today. And I'm happy to join today's podcast. So I'm Alireza. I'm a German lawyer, German-based lawyer. I work with banks, fintechs, and other crypto players. And besides being a lawyer in Germany, I'm also quite active when it comes to law and lawmaking. I'm with associations, different associations, such as the Think Blockchain in Luxembourg. And I was also with the European Commission's blockchain association called E103, where I was a board member and helping with the first draft of the markets and crypto assets regulation. So I have some insights I like to share. Yeah, and besides that, I'm also regularly publishing with different journals, and I'm quite active there as well.
I'll ask Francisco to start by sort of, starting us with the journey of the issuer under MiCA.
Yes, definitely. So I think that in this case, it's important to start from the definitions. As many pieces of legislation in Europe, MiCA has a very long list of definitions, which in this case is contained in Article 3. And the willingness is then basically, as it happens in a sale and purchase agreement, to define everything at the beginning and then have the same terminology used within the entire piece of legislation. This is something that we didn't know, like in the civil codes, we don't find definitions. It's something which is really paramount of the European Union law. And we have two different definitions, one for the issuer and one for the offerer. I think that this was different at the very initial draft of MiCA. Now we have two, and this is something which brings some legal consequences, primarily because it means that the issuer is not necessarily also the offerer, and there are obligations that are on the issuers and obligations that are on the offerer. So let's see what this definition say. The issuer of crypto assets is the natural or legal person or other undertaking who issues the crypto assets. And so it means really like creating the crypto assets. And the definition of offerer is different, natural legal persons or undertaking, or also the issuer, which offers crypto assets to the public. And it's important also to couple these definitions with another definition, which is the one of offer to the public, which is also defined, which means a communication to persons in any form and by any means presenting sufficient information on the terms of the offer and the crypto assets to be offered, so as to enable potential holders to decide whether to purchase those crypto assets. So basically, you need to have the element of an offer to conclude a contract of sale concerning these crypto assets. And there are some problems in these definitions. I would say like the first one is trying to understand what an undertaking is, because we have natural and legal persons. That's the common parlance in private law. Undertaking is not so clear. It's not, I would say, like a legal terminology, and so one can a bit speculate what it means. Some people tend to enlarge a bit this definition to encompass within this definition also constructs like, for instance, decentralized autonomous organization. I would say that this is wrong, because DAOs were within the MiCA, one of the previous drafts, and so I think that we see here the political will of excluding the DAOs, also in the light of this of the recital that we've mentioned in a previous episode, the fact that like fully decentralized organizations should not fall within the scope of application of MiCA, and therefore I would not say that this is an indication that DAOs are also within the scope. I would say more that this is a parlance which was already adopted by the European Union's law, and so it's just like a way of representing the same terminology here. And another aspect is the fact that like the issuer can be an issuer and that's it, or it can be an issuer that offers the tokens. And this is important because I think it distinguishes a bit the spheres also of risks. There could be issuers that create the technology and which do not offer the crypto assets to the public. Whereas for MiCA, things become really relevant from the legislative point of view when it comes to an offer to the public. And so I think that these are basically the provisions on which we can start our discussion and the point of reference that we have to use in indicating which are the obligations that the issuer and that the offerer needs to fulfill. I've indicated that issuer and the offerer can be two different, or it can be the same person. And so like now I think we can talk about the different obligations and the implications in terms of liability. I think this would be the next topic.
Yeah, maybe we start off with talking about the contents of the white paper, what needs to go into the white paper, and start to address some of those terms.
Maybe I can do a very short intro about the white paper, because I'm just like have it ready here.
Just wanted to add something in relation to the difference between issuer of crypto assets and offerers, because effectively the obligations that are being imposed on offerers are much more than those that are being imposed on the issuers. So the scope of the legislator is effectively to protect the general public when an offer is being made to them for the purchasing of crypto assets. So I think this is a very important point that needs to be highlighted. And there's also, of course, the importance to be given to the term offered to the public, which is, I would say, the crux of what would constitute an offerer or otherwise. And I believe that the main question when it comes to offering to the public is what constitutes sufficient information on the terms of the offer. And one would potentially, again, be advised to take a look at case law pertaining to the prospectus directive to see what effectively sufficient information has been interpreted to mean through various case law. Since we'll be looking at pretty much the same definitions granted to sufficient information in relation to the prospectuses, I would say that we can draw a tangent over here, a parallel, and effectively sufficient information then can also be interpreted as meaning the same thing when it comes offers to the public under MiCA as well. So this is just by way of a side note, but I think it's quite important because we don't want to give the impression that just by issuing a crypto asset, you would fall under the full purview of MiCA. The only exception to that is if you're issuing an e-money token, because the mere issuance of an e-money token constitutes an offer to the public. So that is the only exception that one would need to watch out for whenever issuing a crypto asset.
I think that's very interesting, and maybe we can speak a little bit about what is a white paper and how why it is so important. In a way, it's interesting that the terminology used is the one that we're used to from the initial ICOs again. But in a way, MiCA in general was looking into MiFID a lot. So basically the directive that is regulating financial instruments and financial assets. And in this regard, I would say in a very, very general perspective, really generalizing it a lot, it's kind of similar to what the other financial regulation is, but with less obligations. So when we look at the white paper, very similar as it was mentioned before, it is a kind of a small prospectus. It's kind of a document where the holders of crypto assets, especially in cases there is an offering of crypto assets, would be informed of specific information of this project, but also about the token, so about the crypto asset. In general, there is information about the offerer, the issuer, about all the risks, the rights and obligation of this specific crypto asset, and there is many more specific obligations there. There was also a part that was discussed quite a lot and also added in the last part of the negotiations of MiCA, where there was a disclosure of the energy efficiency of this specific technology. So there is a part where the white paper needs to contain an information on how much energy is consumed by this specific technology on top of which the crypto asset is built. And I think this is also very interesting and quite unique until at least to what we understand until now, comparing to other regulations. And it just shows that there is a really important understanding of the European Union that energy consumption is in a way something that they are observing. And it is also a part of the broader, I would say, financial, making finances green in general, and could be, I would say, partially also kind of an outcome of the international political situation that we have in Europe right now and the shortage of gas and energy, of course, linked to climate change fight. So, of course, I think these obligations, in a way, are reflecting also in some parts of MiCA that does describe how this specific white paper would need to be marketed, and also about marketing in general. But of course, the risks that could not be predicted in the future, we need to be in a way realistic, and they do not need to be described in a white paper. So that's very shortly just as an introduction.
Alexandra, you wanted to add something?
Yes, on the I think that's one of the first regulations where energy consumption is linked to, globally speaking, is linked to the blockchain. However, I don't think we have sanctions related or an authority who can say that because you're, let's say, more energy efficient, you should, be ranked better. Or if you, let's say, use the Bitcoin technology for your specific token, you will have lesser points, or you will not be licensed or approved by any competent authority. It doesn't have, let's say, the sanctions embedded. However, I think that is mostly related to the fact that it's expected that tokens will be also bought by institutional players. And banks, investment funds based in Europe, they will need to comply with policies related to ECG. So I think that would be a sort of an information that will be very useful, positively or negatively, depending on the energy consumption, when you want to embark institutional investors as your, the buyers of the tokens that you're going to issue. On the, consumers, it will not make a big difference. Just a parenthesis on this point.
Well, I'm hoping on the energy consumption that it's an estimate, because outside of proof of work, I mean, you start to get into some of the other proof mechanisms. Are you going to start requiring that any issuer of equities has to also say, well, if you're going to trade me on the stock exchange, it's going to take up this much energy. It's like, how much is involved in my processing and all the paperwork and all the additional pages I had to print out in regards to my prospectus that I was doing on paper. I mean, you could it's a new asset class, so you can impose that on it. But on some level, outside of like a high consumption proof mechanism, hopefully it's a very light, hopefully the intent is really to sort of make the distinction between high consumption and something that's really not all that notable.
Yeah, and I think that was very, very well said. In a way, it will more be linked to some other regulation or directives that might be, in a way, finalized in the future, and that probably would have similar consequences as mentioned before. In the future, maybe we could imagine some very energy consumptive technologies and applications being taxed more when it comes to investors or similar outcomes.
Interesting. So, and in terms of the types of disclosures that need to be made in the white paper, certainly in the U.S., there's been a lot of concerns about, just the prospectuses that you would have to, or the registration statement that you would have to get approved by the SEC as part of the registration, or even the ongoing disclosures just aren't well suited to digital asset companies. So, but it definitely, in MiCA, I think they took care not to fall into the same traps. Anybody want to comment on that?
Yeah, I think that one of the peculiarities concerning this type of regulation is the fact that you don't have the approval phase of the white paper. There is a duty to notify the white paper to the competent authority, but basically you don't need an approval for the public offer. And this is something which is made for many reasons. First of all, like the fact that it was held that perhaps it was too much work for the authorities. Secondly, it could be done because of the willingness not to burden too much the projects, and therefore you can notify and start. But at the same time, it's a mechanism which involves, I think, a lot of risks for the offerer. Because if you look at what is this notification, you have to provide explanation also from a legal point of view of why these tokens are not e-money tokens or securities. And this is an explanation which obviously requires the work of a lawyer. And so I imagine that the phase of notification cannot be done by people that are not aware about the law. There must be some legal assistance to do it. And plus, in looking also other jurisdictions, as for instance, Switzerland, normally you notify the issuance, the willingness to offer tokens to the public, to the authority, but you do this in order to have a kind of confirmation that, okay, your token is not a security, it's for instance, a utility token. And so you're sure that you're doing the right thing. Whereas here, we don't have this certainty is not given by the authority. And so basically you notify and perhaps you start with the offering, but you can also encounter bad surprises in a second step if you find out that perhaps your legal arguments to argue that the token is not a utility token are not correct. And so it's something that on the one side should help the offering party. On the other side, in cases in which you have some, let's say, tricky qualification of tokens, is something which might harm the issuer or the offerer because you're not sure on the qualification. And here I also want to stress a difference with the US, because we had this conversations many times with US colleagues, the practice of providing legal opinions on the qualification of a token. And I know that that's really something which is heavily discussed in the US. And a lot of colleagues say that it's basically impossible to get a legal opinion on the token because it's too risky not to say that it's a security many times. So nobody wants really to give these opinions. Whereas here we see that the system brings basically the legal expert to indicate if the token is not a security, because basically you have to explain from a legal point of view why that's the case. And therefore, I'm very curious to see how the legal experts will behave in this case, because of course it's a very gray area. And so we are waiting for the guidelines. We tell it all the time of ESMA, but I assume that they will not be 100% precise. And here I see lawyers that take the responsibility to advise which is the right path. And of course, if it will not be certain 100%, I think that it will be very risky, like to embark in a public offering without being like sure that it's not a token that falls within a category which is differently regulated.
William,
Marine,
you had a
okay.
comment?
Sorry, Marina. Very interesting what you're just saying about the legal opinion and the difficulties, especially in the US, if I ever understand well, to issue a legal opinion as a lawyer, because there is too much risk and not enough certainty. But I think MiCA is supposed to give to the legal experts like a framework to issue this kind of legal opinion, and that's why I found out that this like I don't know, like this regulatory strategy of the MiCA author to say, okay, you just have to notify the white paper. It's not a preliminary approval, so it's not something too hard. Like, I mean, facially, even if we know that you will need a legal opinion, you will need to be assisted by a lawyer. Your token will be, the qualification of the token will be reviewed by both the regulators, but also by all the stakeholders in the market, because, for instance, exchange platform will have a responsibility to assess your white paper and this legal opinion. At the end of the day, it's approximately the same thing as a preliminary approval for me. Like, it's just the regulators that take less risk, but the end of the story is the same. I don't know if you have something to say about it, but.
Well, William, while you're on that point, I mean, for those with their own law firms here, working in a law firm, I know it's hard to project, but what would be your concerns as a law firm, issuing a legal opinion as to whether an issuance is a security or not? I'll start with William.
I mean, from a European lawyer perspective, issuing a legal opinion on a utility token is not. It's not so. It's less risky, I think, that from a US law perspective, because in the European Union we have a written definition of what is a financial instrument and what is not. And with MiCA, we will have a European definition of what is a crypto asset and a utility token. So, of course, it's not perfect. There is still some part of the definition that can be gray, but I'm quite glad. I mean, as a legal opinion issuer, I'm quite glad to have to can rely on this kind of regulation. I don't know what you think about it, Alexandru, or the other lawyer in the room.
No, William, I agree with you. The difference from the US is that, in general, legal opinions requested by exchanges when you're, listing some tokens, based on US law, and we've seen this also based on Singaporean law and other jurisdiction, where this is an utility token, and you had the analysis that this is not a security token, and that's about it. The way it's presented in MiCA, it's a sort of vice versa. It says that you're not an art, you're not an e-money token, and hence you are an utility token. So when you will be doing the analysis, you will have at least 2-3 tests to pass, and then you will get to the conclusion that this is a utility token. Hence, you can issue it, and you are within the scope of the provisions related to white paper. So most probably there are going to be analyses which are going to be more extensive. And what is not clear for me, you will notify the authority. But what if this is a flawed legal opinion? At the end of the day, you will not have an authority to scrutinize your white paper. It's only for notification purposes. So most probably the scrutiny will come from private enforcement. And here I think we have a lot to learn from the type of litigations that we've seen on the US from shareholders when you are like providing misleading placement memoranda, for example, or from Europe when you are like drafting misleading or sharing misleading prospectuses. I do expect that the idea behind is that once you have your white paper, in case you did not act correctly, fair, and without sharing misleading information, you will have private enforcement, meaning more litigation against issuers.
So question on that, so with regards to the opinion though, are you saying that your greater concern is for the lawyer isn't so much going to be the legal opinion, it's going to be more it's going to be the white paper itself? I think that's the point that you're making, that you don't see the legal opinion as being a big issue, unless of course I guess they use some sort of schlock law firm and they issue just something that's on its face problematic. Again, I'm not even sure in that case. I think that's the law firm's issue potentially, possibly less so the issuer. But is that sort of your point, that the opinion doesn't really concern you as much? Meaning, obviously,
the opinion doesn't seem to be public, so it's part of the application for the competent authority. So the public will not see it. First of all, the second point is that the legal opinion will be slightly more complex because you'll have at least 2-3 tests to show. So basically you are showing that, again, you're not an R token, you're not a E token, hence you are an utility token. So, it's sort of a more complex legal opinion that is going to be requested.
But sorry to interrupt, but I do not exclude that issuers, especially those seeking admission to trading, will require 2 legal opinions. A legal opinion drafted under MiCA, but also a legal opinion drafted under the laws of the jurisdiction where the service provider is located. Why? Because since we still have MiFID in effect and will remain in effect for the foreseeable future, you have to see how MiFID has been promulgated under the laws of the jurisdiction where the service provider is located. Because it might well be the case that although the token gets a green light under MiCA itself, potentially under the laws of the jurisdiction where service provider is located, that token may be seen as a financial instrument. So as I said, it is quite likely that in order to be safe, issuers or those, of course, exchanges, when such issuers are seeking digital trading, they will potentially require 2 legal opinions accordingly.
Alireza, you have anything to add to that?
Yes, I mean, I would like to add that what we're now talking is about how the MiCA latest draft from the 5th of October is looking like. We have to note that in the versions before we had, it was not just a simple notification of the regulator. The regulator actually had at least 20 working days time to stop the publication of the white paper. And this has been changed. So what we know so far, also from the securities law, is that the notification is not just a simple notification, but the regulator has 20 days time to check the white paper for plausibility check and if everything is fine. This was excluded intentionally in the latest version of the MiCA. So it is, as Francesco says, it is a simple notification, and the regulator is not anymore supposed to interfere if the regulator is not fine with the white paper. And what I believe, I did not really find the clue or the point in the white paper, but as I remember the last version of the MiCA, it said that you cannot limit your liability inside the white paper. And I think this is a big thing, because now the burden, the liability burden, lies with the issuer or with the offerer, and maybe with the lawyer who gives its legal opinion on the white paper. And maybe this is the reason why the final version of the MiCA says the regulator actually is not really checking anymore the white paper. You just notify the regulator, and then you just publish it, and then you start the offering. And I think it's because of the liability part that you cannot exclude your liability. And if something is wrong inside the white paper, you yourself as the offerer or as the issuer is liable, and maybe your lawyer who gave the legal opinion on that white paper. So this is my personal understanding.
Yeah, that's exactly what I was saying. I'm sorry, why I mean it's very delicate, like to make, then you don't have basically to notify the legal opinion, but you have to notify an explanation of why the token does not fall within another category. And this, of course, requires a legal scrutiny, and imagine that this explanation is based on a legal opinion. And so that's a bit like, I think that this system might work only if there is a kind of collaboration between the authorities and the relevant stakeholders, so that people are aware not to encounter, let's say, bad surprises once they make the notification. Because, yeah, it's true, there's private enforcement, but also the authorities, once there is the public offering, like there's a kind of register of issuance that are offerings that are notified. And so, like, there could be a check also by the authorities in looking inside the elements of this white paper, and then if they find out that it's not a utility token, there might be problems, and basically you put over yourself a kind of light, and therefore it could work, but it depends a bit on the, let's say, inclination of the authorities. What I also wanted to say about Alexandru's indication about the way of drafting this opinion. And here, I also totally agree with what he's saying. If we compare to United States, we have this very broad concept of investment contracts, and I'm not used, but the American lawyers are used basically to assess the token on the basis of the case law. The most relevant case is Howie, and the other cases, etc. Like what a European person normally does, it takes all the definitions that we have of financial instruments, and in MiCA we have a very good list in Article Article 2, Paragraph 3. Like there is the indication of all the cases in which MiCA does not apply, and basically all the kinds of financial instruments, deposits, funds, securitizations, positions. And so I think that the opinion will look like a kind of scrutiny of every item to check, okay, it's not, and if it's nothing, then basically it could fall within MiCA. And here really you see like the willingness of creating a kind of residual legislation, which on the one side is nice, because at least you have legislation. On the other side, we have always to be aware about the fact that it could be a very small scope of application. So it's something which we really need to assess and to protect, I would say, because otherwise all this part does not make so much sense. But like the lawyer that wants to provide a good legal opinion needs basically to assess all the different kinds of financial instruments and arrive at the conclusion that it's not one of them. Otherwise, MiCA will not apply.
And I predict that the white papers will get significantly longer in length as the process continues. They'll probably end up looking more like a traditional prospectus at the end with pages and pages of disclaimer. People be like, I thought this was a white paper. It was like this thick of disclaimers. But and to John's point, I mean, it does sort of, it's not the white paper in the way we traditionally view it today. It's a white paper that probably draws, I think to John's point, I think he was saying that it draws from some of the prospectus requirements in terms of sufficiency and also needing to account for two separate opinions.
Yeah, and effectively also when talking about prospectuses, effectively going to case law relating to prospectuses in order to determine what constitutes an offer to the public. I also just wanted to make a side note to what Francesco mentioned about potentially there being, let's say, law firms which may, let's say, not end up living to the expectations, let's say, that of producing accurate legal advice or legal opinions under MiCA. The way we tried to solve this in Malta is by introducing a role called a virtual financial assets agent, which is effectively an approved lawyer, either professional or law firm, which is authorized by the Financial Services Authority to provide its services in relation to crypto assets. So even if you're a law firm, if you're not a VFA agent, you don't offer your services in relation to crypto assets, because you need to have a certain level of technical knowledge in order to offer your services accordingly. And this role, of course, is not found under MiCA, so now it will be a bit of a free-for-all. However, from what we've seen over the years, whenever there's a law firm which gets the reputation that's not really offering accurate advice, it tends to be shunted aside by the industry. There will be inevitably some cases where unfortunately there will be some disgruntled clients or token teams, but unless there's some kind of centralized intervention to determine who's adequate or who's not, then the market will end up choosing as time goes by.
One item that I wanted to cover, and there's still a number of items to cover as it relates to issuances, are risk management processes. You should probably reframe that, but so like from a transparency and governance perspective, so like some of the things that are referenced when I was reviewing that stood out was one, like the org structure, the risk management processes, the internal controls related accounting. It's on the outline. So I wanted to kind of cover those elements as well before moving on to like getting into marketing and how it's presented to the public.
Yeah, I think that of course. All what we've said requires. But you mean like risks from a legal point of view, or like the legal team, let's say, and the technical team, in order to understand exactly which are the elements of risk. It's the risk is primarily related to the qualification, and also on some characteristics of the tokens. Because, for instance, if the service or the goods of the utility token is not available, that triggers another set of compliance measures and informations that you have to give. And so, like, one needs to have like 100% clarity on all the different issues. And yes, this is I think a very important element. Plus, you have also to consider that, like, there are a lot of indications concerning the risks that also the person as such can encounter, and these are mandatory, but they need also to be understood, like the risk that the token goes to zero, and the risk concerning the technology, and also there, I think that there must be like an understanding. And then, as to the risk management, one has also to remember that this piece of legislation is not like a standing alone piece of legislation. There is there are all the other legislations in the EU. I'm referring, for instance, to the privacy GDPR regulation, but also the rules on cybersecurity, data storage. And so, like, if you do an offering and you, I don't know, collect personal data of the buyers, then of course you have to make clear that you need to comply also with GDPR law if you deal with European customers. And so, like, it would be naive to think that you do this and it's fine. Like, within the white paper, there are some obligations that need to be fulfilled that require a certain amount of compliance. But then there is the rest which also apply. And like, first items are privacy, cybersecurity, and of course, like AML, KYC.
Just to follow up on Francesco's points, we have, Article 13, where we have some, clarifications on what will be the obligations of the offerers and persons seeking admission to trading of crypto assets. And apart from communication, there is a point related to risks where it says that you should maintain all the systems and security access protocols to appropriate union standards. So what we expect here is, as Francesco was saying, we will put together for internal procedures. Of course, we will be waiting for instructions from EBA and ESMA on this specific point later on. But it's going to be a sort of, again, you need a sort of a multidisciplinary team, because it's the way it's written now, it's pretty broad, so it will encompass all sorts of risks. So a sort of a risk mapping will need to be done. If you're going to trade on a centralized exchange platform, I'm pretty sure that the exchanges will be sort of helping or providing this sort of information that they would need from you. So in a way, the regulation on this type of risk mapping and mitigation will come from the ecosystem players. I expect a lot from exchanges and what they will impose as risks there. A second note on the on this Article 13 related to obligations and risks is the fact for the first time we have the concept of acting in the best interest of token holders. If you look at the old, the old ways of the ICOs, nobody was, everybody was talking about consumer protection, but we have this new concept, and it's interesting how this will unfold in terms of case law at European level, because we are getting as near as possible to the shareholder protections. When you are a company, you act in the best interest of your shareholders. So MiCA is creating this analogy. Unless you made some specific carve-outs in your white paper. What does it mean? Because here I think we have a gap. We've all seen tokenomics in white papers. A lot in the tokenomics, it's related to scarcity, on how the whole amount of tokens will be shared between team, investors, and users, which doesn't look. So when we look at all the elements that a white paper needs to contain, these specific economic terms are not mentioned. I mean, there is a line saying that you need to describe the rights and obligations of token holders, but this is far more than that. It's the way the dynamics of the token ecosystem will look into it. Most probably ESMA will be covering this in the instructions, but this I see as a gap. So in scarcity is not clearly delineated, or basically you're not obliged to write there how you're going to split the total amount of tokens. It's not written if you're going to have halving or not. The economic model. So I think that's one of the gaps in a white paper as we see it now. It's also true that buyers and consumers are becoming, hopefully, more sophisticated in the crypto world, and those will be elements that will be requested by the market or by your institutional investors if they want to invest in your tokens. But the way it's now presented in MiCA, there's still to be more information will be needed. What MiCA offers is a sort of high-level approach. I would expect more information to be there. So yeah, we could get, as Eric was saying, in a long 200 pages white paper, unfortunately.
And then as it relates to cybersecurity, certainly the issues presented by issuers as it relates to cybersecurity, and maybe even more so like certain kinds of protocols, they're very different than arise in maybe your traditional prospectus. But nonetheless, if you're making disclosure as to risks, you still would have to address them. How do you see cybersecurity concerns impacting what needs to be disclosed in the white paper coming in from other regulations? How do you think, because it seems what you're describing is like the white paper is your opportunity as an issuer to ensure that you're complying with all your other disclosures. I mean, I guess theoretically you could find some other ways to disclose some of these things, but I think I would imagine the issuer is like, if I'm putting a privacy policy on my website, maybe I want to make sure that it's end to end with what I'm disclosing in my white paper. If I'm making certain other disclosures, that I'm required to do, maybe I want to be safe and ensure that's in my white paper so that I don't, I mean, why take the risk? But curious as to thoughts on that.
Yeah, I think that all this European regulations, GDPR and cybersecurity, and like there is a way of complying which is very formal in the sense privacy policy or indicating which are the measures, etc. And then there is a substantive way which involves really the organization that you've set in place and the safeguards that you really have. And it's kind of front end and back end. And you arrive at the back end only if there is an issue going on, so a control or some signaling. And I have to say that my feeling is that many do not have this substantive compliance set in place in this moment. But I think that here, like if you look at the European law, all the indications are very generic in the sense of having safeguards, storage which is secured. So you don't have like technical solutions, of course, in the law. And I think that best practices are important, and also the fact that you can show a solid audit concerning, for instance, the technology that you have created is something which might put you on the safest path. And so I think that in the end, what will happen is simply that you are going to follow best practices, but you will have a kind of standardized scheme to indicate what you've done. And like this is a bit the goal of European Union, that basically for people that want to know, that want to have the information, they can find this information and they know that this information must be there. Then it's only a minority that looks and that reads and that understands. But at least like you create a kind of structure which should bring the issuer and the offerer to comply with all these indications. Then like I wanted to, because we talked about accountability and potential liability, and there is an article that deals with these matters, which is Article 14. And I'm very curious also to hear my colleague. This article is somehow interesting. It is, I would say, a private enforcement article in the sense that it's made basically for persons that are affected by the token, in the sense that the token is not what was promised. The wording that it's used is, in my opinion, very like a technical. The white paper information, which is not complete, fair or clear. This is the indication that is given. And basically, if you have one of these cases like unfairness, ambiguity, or you have gaps within, basically you can sue the offerer and ask for compensation, but you have also to demonstrate, this seems to indicate paragraph 2, that all these ambiguities have brought you to buy the token, basically a kind of causal nexus between the wrong information that is within the white paper and the damage that you have encountered. Like I think it's difficult to basically satisfy this burden of proof, because if you read in the white paper the token can go to 0, then I mean you have to live with it. And so I was trying really to understand. In reality, I think that the we would have here are only cases in which you say the token is not a utility, it is a security, because you created some sort of expectation of profit. Would be a case, I don't know, similar to the compound case which is filed right now, or the cases that were made against American exchanges that like assuming that they were dealing with securities, in which you try to demonstrate that the token is not a utility, because like saying that the information is not clear, that it's that it has gaps, and that therefore you bought the token. I think it's something which is very difficult to encounter in case law. But I'm curious also to hear what the others. My feeling is that given also that like in Europe we don't have this class actions which are made in the United States, where basically you have the class and people that jump in and are part. It's something which is beginning to in Europe, but it's really a different, completely different story. My feeling is that the level of deterrence of this Article 14 is almost 0. So it's more on the authorities than on the persons that are rugged. Excuse me, sorry for the terminology.
On you've raised a very interesting example and incident, because I think this may well lead to potentially there being two camps being set up. And I'm going back to the definition of offer to the public, because effectively there has to be the presentation of sufficient information on the terms of the offer. So you'll find those offerers which will somehow craftily try not to include sufficient information so as to enable potential buyers to purchase those crypto assets so that they can argue that they fall outside the scope of MiCA. But then you have the other camp, which will be presented with sufficient information. And as Francesco explained just now, those terms then inevitably need to be clear enough so as to effectively exclude any liability or most of the liability in case things go south. So ultimately, the decision should be, the information should be sufficient to enable the potential holders to decide whether to purchase those crypto assets or not. But then there has to be sufficient carve-outs in order to effectively try and limit liability as much as possible. Even though I believe Article 13 or Article 14 specifically stipulates that if the carve-outs are too, let's say, explicit or too flagrant, they will not have any effect. So effectively, the offerer or the service provider, as the case may be, may still be found liable in terms of potential civil liability. So it will be interesting to see how this will play out in terms of which carve-outs will be, let's say, accepted and may potentially exclude liability and which ones will not.
This is exactly what I was talking about before. I mean, I heard you both, and I agree with you both. So, however, I think exactly this Article 14, the exclusion of limitation on liability, is very broad, because exactly the paragraph you said, it reads, with regard to civil liability, as referred to in the previous subparagraph, any contractual exclusion thereof shall be deprived of any legal effect. So in Germany, at least, we prefer to have in terms and conditions a limitation of liability for negligence. So we cannot exclude intentional actions and gross negligence, but minor negligence we can exclude. And so what I think is very interesting, the MiCA is a framework which is actually a regulatory law, and now it interferes with civil law. So it does not allow civil law to limit the liability, even though you're absolutely right, Francesco. It says anything which is in relation to the I'm gonna read it out loud because the wording is very interesting. So anything in the white paper information which is not complete, fair, or clear, or by providing information which is misleading. So we can talk about the completeness, because the list of the white paper, what the white paper has to cover, is very broad. So if anything of that is missing, or if you update the white paper and you forgot to change anything and it's misleading, it could cause the liability of the offerer, of the issuer. However, as you said, Francesco, the holder has to prove it. The holder has to prove the evidence that this misleading or this error caused a damage with the holder. But what I really find interesting is that a regulatory framework is not allowing civil law clauses any longer, which is very, very much common, I think, also in the US and in England, but in Germany definitely, to limit your liability for actions which are intentionally or gross negligence. So minor negligence is normally excluded. However, this is not working any longer with the MiCA text. Yeah.
If I may, so just to make a comparison with the US, civil law in Europe is still a matter of each member state jurisdiction. So you might have a conflict of supremacy here. Because MiCA is coming, it's getting with this clause within the national jurisdictions where civil law it's still within the borders of each country. So it's very problematic. I don't think that the German courts or the Romanian courts will take this for granted. And my expectation also on the fair complete, which by the way, complete a document is never complete. There's always something you can, bring further. So in a way, this could be a sort of a probatio diabolica, as the Latins, would say. It's very difficult to say that something is complete, for closing the parenthesis. But my guess is that these concepts will get in front of the European Court of Justice if MiCA will pass like it is. Because even if we receive instructions from EBA or from ESMA, those are not directly applicable. They will be a sort of a light law or some practices. So in order to have a sort of a cause of action, unless this is clarified in MiCA regulation, nobody else apart from the European Court of Justice would be able to interpret this language, and then it will be the decisions of the European Court of Justice are directly applicable in all member states. So that's my guess with this language.
I think what's very interesting is when we are expecting the report or feedback from ESMA and EBA, we do have guidelines and regulatory standards. And so the guidelines are the ones that are very much like something that can be taken and probably will be taken into account. But the regulatory standards are the ones that will almost be very similar to a law. And there is a whole list of all the things that we're still expecting from EBA and ESMA to understand MiCA better. And maybe thinking about the future, as was mentioned last time and this time too, there would need to be updates, or if there's new, let's say, offers done, there would need to be new white papers issued and also sent to potential authorities. So what's interesting is that besides the laws that we have today in the EU at the moment, there's a lot of, I would say, work done on different directives and regulations that might also impact the risks and, of course, the obligations that we can see written in the white paper. So, for example, we are now finalizing the whole AML package that is going to be definitely the one that is going to impact those projects a lot. We also are discussing the new Data Act that has a specific article that is defining how the smart contracts need to be designed in order to be compliant with the Data Act. So this is definitely going to be something that those projects will need to take into consideration. And also some additional parts as the Cyber Resilience Act and Product Liability Directive. They're going to be updated, and they're going to be very important in terms of what is the responsibility of specific project, but also in the end of a programmer that might be the one that is programming this specific smart contract that is then used in this part. So I think there's going to be a lot of work, and at the same time, I know we'll have the discussion about crypto as a service providers, but what's also happening in some of the laws that we see now being discussed is that we will not have one definition of a crypto as a service provider in Europe, but there will be different definitions in different, let's say, regulations, if there's regulations or directives. And that just shows that, of course, all these lawyers working on these matters, there's going to be a lot of education needed, and of course updates from all these laws in the future.
No, just wanted to add, but because as Alex rightly pointed out, I mean, some of this language over here, and also harking back to the first episode, use, for example, the term full decentralization. It is very odd to see this kind of language being used in such an important legislative instrument, which begs the question, are the European authorities rushing ahead with this regulation as a knee-jerk reaction to what they are perceiving that is happening in the crypto asset space? And it may well be that effectively this regulation will be issued, and then all these problems, all these issues start popping up, leading back to the question, have we rushed this regulation or not? So just wanted to make this point, because in my opinion, this regulation is just being rushed ahead of its time without giving due considerations to all these important points, which are now being, of course, which are now cropping up even at such levels of discussions.
Well, so certainly you make you raise a controversial point there. Speaking from the U.S. perspective, I guess to juxtapose, in the context of MiCA, there isn't an effort to start to put a framework in place, however imperfect. And I do want to kind of circle back on this liability point because I think it is something that bears even more discussion. But if you contrast that with the alternative, the U.S. I mean, in the U.S., we're still using terms like investment contracts to describe these things, which, really doesn't make sense when you're extending into the secondary market or in its application or trying to enforce a disclosure regime. And again, this is not really just to rain on the U.S. It's really just to say that this business is happening today. The legal system in the U.S. is poorly designed for it. It's largely a lot of the policy is being dictated by the SEC without sufficient guidance from Congress. It's really becoming almost like an agency, and I would say it's a very small group of people that are really driving these interpretations fundamentally. So others may disagree with the size of that group, but I guess, to the U.S., the MiCA seems like an effort to set a framework. To suggest that it's premature, I mean, I guess it's an open question. We don't have to debate the esoteric nature or the existential nature of it, but the perfect can often be the enemy of the good enough or the good. I don't know. Thoughts? We could spend a little bit of time and then sort of hit on the liability point.
Yes, I agree with this with the statements, and it is something which, for instance, another element which was not mentioned until now is the fact that this first part of the legislation takes into consideration possible changes in the nature of the token. And I think that's also an interesting point because, like in the US, we had this discussion of the morphing, like the token that was a security and is not anymore a security. There is the idea that basically the token can start as a utility token, but then can become something different. And it points to the offer and basically stating, look, if the token changes nature, it could be the case because, for instance, I don't know, the lead is taken by the governance in order to change some characteristics and make it, I don't know, a token which creates a revenue for the token holders. Like in this case, in theory, there is a duty of notification and like you have to modify the white paper. And what is not so clear is what happens if the token stops to be a utility token and becomes something different. And in my case, I think that in this case, basically, you should reveal the true nature of the token, and so it's like you see also here that it's an incomplete legislation because it does not solve all the problems, but nonetheless there is like the capacity to determine that the token is not something which remains the same in its entire life. It can change because it's something to which basically functionalities are attached. And then I wanted to retake, even though it was a bit of time ago, but Alireza pointed to an interesting aspect, which he basically stated it's not only regulatory, this first piece of MiCA, there are also elements of private law. This is something which is very continental Europe focused because like we are used to basically create partitions within the law. And I totally agree with him. I think that we find a lot of elements which are private law, plus also consumer law in some cases, like this right of withdrawal. We have it in financial instruments, but here it's like more related to protect the weaker party, which is an element that we have often in consumer law, European consumer law. And I think that this is given by the fact, the reason is that like the European legislator really believes that there is this category of utility token where you basically buy a service and a good. And so that's why service and good basically is a kind of contract of sale where you're buying a service or a good, and the token is given to access this service. And so it's seen not as something which is under financial law, but under like the normal private law. And we basically consider contract law as private law. And so that's the reason why I think we have this elements. And so like this was an interesting methodological consideration because like it's not financial law. It's like private law, and private law is where we find the freedom of the citizen, and this is something which I really like.
I think what's important to mention is that we have an article in MiCA that talks about the revision. It's the revision clause. So the European Commission, after discussing with ESMA and EBA, 18 months after the entry into force, basically, it will send and write a report on all the things that might be missing and all the feedback that they will, of course, see and accept. And I think that this is, in a way, again, forward-looking, but most of it will be linked to DeFi, will be linked to borrowing and some other aspects. So I think that they are already thinking about it and working on it. And again, it's going to be quite interesting to see, and of course, to collect all the feedback from different stakeholders.
I also hope that they spend less time, or rather they waste less time discussing these environmental concerns, etc., when it comes to proof of work blockchains, and focus on some of the other matters that, again, we're seeing cropping up and can effectively lead to such issues, such as, for example, MiCA not working as well as originally intended, especially the issue that has been raised, I think, in the past episode. I'm not seeing how maximum harmonization can be achieved with the MiFID II directive still being in place. So I think there were a lot of instances where discussions were being waylaid by certain factions of the European Parliament. I just hope that effectively the discussions going forward are focused on, again, these kind of issues, which I find quite worrying. And I don't know whether I'm just perhaps personally overthinking it, but again, these issues do worry me quite extensively.
Yeah, I want to second this indication, because I was really astonished how much time it was wasted in talking about proof of work, about people that don't even understand the technology. But it was really a hurdle. It was considered, because it's a very easy argument that you can raise. And of course, like, it is also an argument which creates tension within the parliament, because historically, like, parties are set in a certain way. And so it was astonishing, because as like Eric was saying, it's something which affects proof of work and not the others. And also on proof of work, you can make a lot of comments on this, because in the end, it depends on the way in which you create the energy. But even if it was stupid, I think it was a great obstacle that was overcome. So I was happy. From a legislative point of view, I think that all this FTX stuff brought to more attention to the relevant parts. That's my feeling. Because obviously, like, this question of would European law have prevented such a thing from happening has really focused all the work on the parts that are more relevant, and not on this stuff, which is more like political debate and substance.
Well, talking about the liability in the context of FTX, I mean, you know, it raises a question, particularly, you know, once it's in force. This concern regarding liability could come to the fore as a real practical matter. Like, and I guess question for the group is, do you see an issue like this, or maybe there's others that you think dwarf it? Do you see an issue like this potential liability within your jurisdiction leading to, again, concerns about lack of clarity, like we're trying to avoid with all this, and also potentially even have a chilling effect where we say, okay, you know, MiCA is phenomenal, and then, like, after a little bit of playing with it, all of a sudden there's a realization, like, wow, there's a lot of potential liability that we're assuming because of this, and again, you sort of haven't achieved your objective, and then potentially trying to address this liability issue in the face of an FTX might become very challenging. So just curious as to, you know, how you see this potential liability issue playing out once it's implemented, and even the prospects for affecting some sort of change.
Perhaps not answering the question directly, but regulation can never be sort of like the silver bullet to end malpractices, fraudulent practices, etc. So a regulatory framework is precisely that. It sets the framework, it sets the expectations, and sets out the obligations for all licensed entities. But a regulatory framework without supervision and enforcement will effectively not be effective at all, I would say. I would argue that. And if we were to, let's say, take the FTX scenario and apply it to let's say, the hypothetical scenario, and what if they were regulated under MiCA, on which Francesco also wrote an article. It's all well and good to have the framework in place, and at the application stage and licensing stage, there would have been in adherence there too. But then what happens afterwards? So I would say that the same thing can be potentially argued for let's say, liability. You can have these kind of articles stating what you may actually be liable for, but if no one's checking what you're doing, then effectively the liability can be enormous. But if no one's checking, then you'll never be found liable for that as well. And I think the concept of supervision and enforcement should not only be focused on the entities that you are directly supervising, speaking about MiCA, for example, the crypto service providers, but also as well all the other entities that are also regulated perhaps under frameworks, such as the banks, for instance, because there were various other incidents, non-crypto related, where effectively those that were directly involved in some malpractice got punished, but those who were maybe ancillary to that malpractice were never punished, including the banks. So just wanted to make sort of like that general observation, because again, I'm speaking here from experience where effectively certain, let's say, incidents in Malta didn't lead to, let's say, perhaps a revision of how such entities were being supervised, but they resulted in even further restrictive measurements in the law itself, which just lead to a stifling of the business. So that's what hopefully should be achieved over here, that if we see perhaps certain incidents where effectively there may be service providers that, again, fall foul of MiCA, I'm just hoping that at a later stage, it's not just making the framework even more onerous, but rather perhaps reviewing and seeing whether anything could have been done differently, for example, from a supervision perspective.
Maybe one comment here is that when FTX happened, from what we can see in the US, there's been a huge discussion and, of course, a lot of reactions to that. MiCA was already finalized at this stage, and so there was no changes made after what happened with FTX. But what we have seen in the last weeks is basically, first, the countries, member states, they will need to wait for another I would say almost 2 years, 1.5 years, for MiCA to be applicable at the end of the day. What should they do in between? And the other thing is that we've seen also different institutions and regulators in Brussels really thinking of what can we do in between? Can we add something? Can we do something to, in a way, improve the situation? There's been also a public hearing in the parliament, and we have seen those discussions lately. In a way, I was just recently talking to a regulator, and what he says is that if MiCA would be in place, more or less similar, I would say, at least similar regulations are in place in France, maybe Germany and some other countries where they do have some sort of a crypto asset regulation, but some of the member states have zero regulation. So if MiCA would be in place, maybe, again, the supervision would be done in a better way. And at the same time, as I agree with the critics, what we have seen is for example, national competent authorities like BaFin and similar organizations, or also on the level in Brussels. I think we need more people that are crypto native, or they really deeply understand this topic, because even in the future, when we're going to talk about AML and some other issues, we'll need more, I think, brain to understand this and how to follow up with all the potential problems that will happen in the future.
Yeah, I have a question for all of you. As you probably know, in France there is a project to accelerate the timeline of MiCA for approximately 1 year. So it is the answer of the French government to your question, Marina. But have you heard in other countries, maybe in Malta, in Germany, if there is similar willing to, I don't know, to implement MiCA in advance or to accelerate the timeline of MiCA or to have other measure based on the FTX scandal?
So I can speak from the Malta and Liechtenstein perspectives. Malta, for instance, already issued a public consultation paper to start excluding NFTs from the scope of the local virtual financial assets framework. And also, I believe the Malta Financial Services Authority was the first authority to publicly announce that it will be granting the full transitory period afforded under MiCA, under Article 123, to all its nationally regulated service providers, since it deems that the VFA framework is already quite close to the MiCA framework in effect, including the prudential requirements. And I can also confirm that the FMA in Liechtenstein is also already undertaking work to start approximating its DVTG, the Blockchain Act, to MiCA as well. So there are actually active ongoing efforts by quite a few FSAs and governments to effectively start doing the necessary work to approximate the national frameworks to MiCA.
So that's very interesting. I mean, I didn't know about France going to make the MiCA regulation being applicable after 12 months. Correct. That's what you said. So in France, the MiCA regulation is going to apply not after 18 months, but after 12 months, right?
No, even before, but only for the new application. So the current registered people will keep the MiCA timeline. So they will have almost 36 months if you take into account the grandfather clause. But for the new applicant, we have a national MiCA license with name the DISP license, whatever. So the new applicants, they will need to ask for the DISP license, will be converted to a MiCA license in 18 months when MiCA will enter into force. And yes, for this new applicant, the deadline is set on October 2022. Will be set approximately around October 2022.
As a proud Italian, I also wanted to say something about Italy. And like we have now a very soft regime of registration of VASPs, which it means basically nothing. You can register, but there are two components which are important. First of all, it is required that the VASP, if it wants to offer like openly to Italian customers, needs to have at least an establishment in Italy, so some sort of organization in Italy. And plus, it must comply to AML and KYC if it offers to Italians. And so it's a first scrutiny, and I think that it's an invitation to basically be put under the scrutiny of the Italian Authority for Financial Markets. And like in the last there is this authority which basically holds the register, which has a newsletter. And it was interesting because they basically stated we had 80 applications, etc. And nonetheless, there are like 12 that are very big that did not apply, even though it seems that they offer services to Italian customers. And so, like, I think it's basically the beginning of a wider scrutiny. And there are a lot of players, but the big ones, the very dangerous ones, are not so many in crypto. And so I think that there is the willingness of controlling them in the first place. This is my feeling.
So what I wanted to add on that, I mean, we have the same in Germany. I mean, the German regulator and the French regulator, I would say they're competing with each other. So the German regulator and the German law allowed to have a crypto custody license and crypto trading from the beginning of 2020. So now we have in Germany 5 crypto custodians, including Coinbase and Bitpanda and others. And we have some who have applied for the license, like Binance, and by the goal to receive the license before MiCA comes. Or MiCA is absolutely not just effective, but applicable. That's the right word. So, and in Germany, you can do this called simplified procedure according to Article 123, paragraph 3 of MiCA. which means if you're already regulated before the MiCA is effective, and you can just use your license and upgrade to MiCA. And this is something I was asking the German regulator how this is possible. And as I understand, you in France, this may be possible already for the existing regulated, maybe custodians, 12 months after the MiCA is effective. In Germany, however, they said they want to wait for the entire 18 months. And then there's a new law coming, which is called something like an implementing law, which is going to change the existing German crypto law and which will allow those who want to upgrade to MiCA to upgrade the existing license to the MiCA license with a simplified procedure.
Interesting. So maybe we'll rotate back to sort of finish up on the issuances and then maybe start to talk about the CASPs with the remaining time. Do we want to talk a little bit about marketing of the white paper and the issuance versus the disclosures themselves? That's a question. The disclosures are part of it, but the way that you market it to the public.
But I don't know what is your opinion, but I think it's a quite important topic actually, because I assume it's all over the same, but at least in France, and I'm sure it's all over the same all over Europe. We have witnessed very very hard marketing technique by the crypto asset industry, both the good and the bad players. In the last I don't know 2 or 3 years, and especially since you have this new saving wallet or like earning product, and I know that in France the regulator is more and more strict on the marketing techniques that have to be implemented for the marketing method and the limitation to this marketing method that have to be implemented by the virtual asset service provider. They ask virtual asset service provider to stop how do we say like not providing enough information about the risk that are on all of this product, especially the earning wallet, all the yield product and the stable coin, who are like not so stable if you listen to the French central bank and all the central bank in Europe. And it's I think it's a quite important topic. I don't know if you have a other feeling.
Yes, and also this is something which recalls a bit European consumer law more in general. There is a directive which is not known obviously by US persons, but it's a directive on misleading commercial practices. And if you look at the wording of Article 6, which is the wording which is the article on marketing, there are some guidelines for marketing concerning tokens. A lot of elements are, in my view, retaken from this directive. And communications must not be misleading. And plus, there is also some mandatory wording that you need to use into the marketing campaigns. And basically, you have always to clarify that no authority has accepted the tokens as financial instrument. And so there is the willingness of creating basically a strong educational indication about what you can say and how you have to say it. And this, I think, is very good, because it triggers then a direct control of the authorities on the basis of what you say. And here, I think that the good lawyer needs also always to advise what you can say about the token issuance, what not. But nonetheless, even in the US, where people are very careful about the wordings, if you look into the compound case, I mention it again because it's interesting. A lot of assumptions concerning the nature of the tokens are made on the basis of declarations of the founders or of tweets and other declarations that are made on networks. And so I think that really there must be an effort to well educate also on this respect, what you can say and what you cannot say. And the white paper, as we've said before, it's a very very detailed and complex document. In the end, my feeling is that nobody will really read this except people that are very technical, but not the normal retail investor that buys crypto sometimes. And so marketing becomes more important because basically people will rely only on this. And the fact that we have this stressing of the importance of marketing means that basically this will also be one of the elements that will be assessed by authorities. And if there is a misleading communication, I imagine that they will intervene.
Yeah, I want to add on that. I mean, from a practical perspective, I'm absolutely with you, Francesco. I mean, the token issuers and the offerers, they will say, yeah, we have the white paper and no one is going to read it, so we're going to publish it here, and it's such a lengthy document. And then they reach out to their operations and marketing department and say, go ahead and now do the marketing. However, this is exactly what the MiCA is not allowing, because it says clearly that the marketing communication shall be consistent with the information inside the white paper. And this is something which is very important. And I think this is something where we need to look at when we are going to see what is happening in the future with the white paper and the marketing, that they're both aligned. So there's no like marketing saying this and the white paper saying something totally different. And this is going to become very interesting, I think.
Alexander?
On this one, social media. We all know the channels, Discord, Telegram. I mean, marketing communication should be published. I think also this type of communication is to be paid careful attention to, because from my experience, a lot of the sentiment on a token is built within the channel, either Discord or Telegram, where a lot of evangelists are coming. They are saying, well, this is going to the moon and stuff like that. So this type of marketing practices are not clearly reflected in the MiCA, and they are very practical. They happen all the time, and we've seen also as a co-founder of a crypto project back in the days. Most of the marketing that we were doing and discussions with the users within the ecosystem was on Telegram, and we had customer support and people helping the others to understand better the functionality of the token and how it could be used in the specific ecosystem. But most of the information and the feeling and the impetus to be part of the ecosystem, to buy, to sell, it's not on your blog as a token issuer. It's in this type of groups, and for that MiCA is not coming necessarily with a solution. It's true that it also needs to be left to the market. I mean, if in a channel the channel owners are shilling incorrectly, unfairly, you name it, we take the language from the MiCA, a specific token, those information corroborated with the white paper that you have and the marketing communication could show a mismatch, but again, it will be a matter of private enforcement.
I want to add on what you said, Alexandro. Sorry for jumping here. So if you would just imagine how this would work in the future, you have a Telegram group, you have a Discord, you have something else, and someone wants to run marketing there. I mean, the MiCA says that in any marketing language, you have to put some mandatory language. You have to say that this is marketing. You have to say that there's a white paper. You have to say the address, the website where you can have access to the white paper. You have to put the telephone number, the email address of the contact persons. And then you have also to add a sentence which says, this is crypto asset marketing communication, has not been reviewed or approved by any competent authority in any member state of the European Union. The offerer of the crypto asset is solely responsible for the content of this crypto asset marketing communication. So if you can imagine this, putting all of that language when you want to do marketing on Telegram or Discord, I think it's impossible to do that in the future. You have to build up some different marketing channels where you have to put such disclaimer and wording on top or at the bottom, and then you can continue and do your marketing. But with this requirement, it's very difficult.
it's also true that, let's say, once you have bought the token, so you publish the white paper, you have the communication, and then you have the initial offer, and you have users. Once those are into the ecosystem, of course they can create groups on Telegram and discuss on on their common interest in the ecosystem. That would be out or within the marketing obligations of an issuer when they communicate with the those people within. Again, not solved. Thank you very much, William, for leaving me this parenthesis to be made.
Just also, let's not forget that there's Article 80, which prohibits market manipulation, and part of it is also targeted at all these social media influencers, etc., which, let's say, try to push the price of a token to then later dump it on. So this particular article should hopefully also, let's say, as much as possible, curb any such instances where there are, for example, pumps and dumps happening, and at times potentially the token issuers may be indirectly involved by engaging with these so-called influencers. So hopefully this article will also serve to cut down a bit on that abuse as well.
Yeah, and I'm also yes, I wanted to say similar things, and also the fact that consultancy in crypto, if you want to give some kind of financial advice, it's now within the services which are regulated. You need to get an authorization to do it. And so for the European influencer, this would be perhaps a risk to do this. Of course, then we have to see how effective this rules will be, but no, there is there is at least the attempt to also try to scrutinize this kind of behaviors.
But this discussion is very interesting because we see two very different things that actually meet in crypto right now for the last few years. In one side, you have what you were talking about, Alexander, is that we come from a complete far west about communication related to crypto asset, ICO, NFT, issuance, everything. And I think this MiCA will not stop it from perfectly, but MiCA will create a framework and will create practice market that will considerably restrict this kind of totally unregulated promotion of crypto asset, because every players in the market will be at risk of enforcement by the regulator. For instance, if you are doing something wrong in your Telegram channel, you will have the risk to be delisted by the exchange platform. For instance, if your regulator put you in a blacklist, that is something that is more and more common right now. So I think the level of regulation will rise all over the market, and it will not be comparable to what we see now when you have some exchange and some brokers that are regulated, but all the other players in the market, it's still the far west. And the other thing is that, it's much more broad than the crypto market. We see in all of the financial industry, we see a kind of, I don't know the name in English, but a social networkization of investment and social networkization of promotion. You see that with Robinhood, GameStop, a lot of situation like this. We see a lot of investment advice on TikTok on every kind of financial asset actually, and the regulator right now are still not really able to I don't know, to handle this situation, but I'm sure that they will, as usual, rely on the social network and on the platform to do the job, because you cannot regulate people on TikTok, but you can ask TikTok to try to clean the mess on behalf of the financial regulator. So this is what I expect for the next 5 years approximately.
Maybe just the last comment. Let's think about projects that are more collaborative. I'm not saying they're DAOs, but they might be DAO-like organized. And in this part, there's no shilling of the price of the token, but it's really kind of collaborative discussion within a Discord, because this is in a way where those projects were coming from. And what would be the implication of this? And in a way, also, I would say, leading to what was happening in the US, or kind of observing the US, I would say, laws, or at least like an idea what would best practice be from there. A lot of already Telegram groups and other social media, they're not discussing prices. There's a strict policy for not doing that. And I think that might be something that might continue then, of course, under specific and more structured laws as MiCA.
Let's talk a little bit about the right of withdrawal for specifically with regards to utility tokens. What precedent do you have for this in Europe, and how do you, what do you see as some of the potential issues or concerns that are connected to this?
Yes, like the right of withdrawal is really the European pioneer for harmonization. It was one of the first harmonizing rules at the European level in 1985, like for sales that are made outside of the shops. Basically, you had this right of withdrawal, and the idea was that you are surprised that you're not able to assess, and so you get basically surprised. And then it was added in the 90s to distance contracts. And this was a kind of invitation to European customers to buy from other countries, because they could then use the right of withdrawal if they didn't like the item. It became very, very important with online sales, because like every European customer is aware that even if he buys in another country, he can exercise this right and basically look at the item, and then if he doesn't like it, he can basically jump out of the contract. And nowadays it's very used at the European level, and so I also think that here there was the willingness to implement this rule in a context which is different. We had the same also for financial instruments that are bought outside of the location of the intermediary, and so it's not new. And I think it's not so important. It is like an element of protection for retail investors. So it's not for everyone. It's only for retail investors. That's the same also normally in European law. Like the consumer can do it. So if I buy a tablet, an iPad for like playing, then I'm acting as a consumer and I can exercise the right of withdrawal. If it's something that I use for my profession as a lawyer, I'm acting as a professional, as a business, and I cannot use it. And we find the same in MiCA, because only retail investors can exercise the right, and not like institutionals or people that do this as a profession. Why? Because they need to be aware about, they need to be able to assess what they're doing. Whereas the idea is that the retail can be basically catched by a lack of experience, and so there is this willingness of giving a cooling off period and the re-exit from the contract. What can we say about this? First of all, it does not apply if the token is already accepted on a trading platform. And this, in my view, limits a lot the scope of application, because if there is a price, obviously the price fluctuates, and you don't want that the retail investor basically abuses from the existence of this right, and so it's excluded. And so we're talking only about tokens that are not yet in commerce. And here, I think that it will be a kind of problem for the offerer, because you need to implement, of course, like an organization which allows to give back the money and retain the token. And so it's something which will need another layer of compliance of organizational settings if you want to launch a token which has not a price. Right. But it's definitely something which continues a bit the path of European law, so it's not surprising and perhaps not so bad.
So, I absolutely agree with you, Francesco, and thank you for the summary. What we need to pay attention to, however, because as I'm also from Germany, and we have this right to withdrawal with the normal consumer goods, which you can buy online, and then you receive it, it gets delivered to you by post, and then you have at least 14 days to check the asset, and then you can give it back. And here it's different. The 14 days which the retail holder has starts to count from the day when the purchase agreement is agreed. So For instance, I go on the web page of the issue of the offerer and I say, I want to buy this utility token. And I say, okay, I want to buy it. So this is the agreement. And then the 14 days start to count. And I have 14 days to withdraw my offer, yeah, or to withdraw my intention to buy. And so what I believe is going to happen in the future is that those who offer such tokens, such utility token, which are not listed on an exchange already, they will only deliver the token after the 14 days. Because if they do it before, they will get into this mess what you just described, Francesco. They need to get the token back, they need to pay back the money, and all of that for free. So the retail holder is not supposed to pay for any of that. There should be no fees. And if I would be the lawyer of an offerer, I would tell them, okay, do it like this. You tell them, if they want to get the token now, they have to tick a box that they will not make use of the 14 days withdrawal. Otherwise, they will only get the token after 14 days because we have to wait for 14 days to see if he's making use of the right to withdrawal. And I think this is going to be the future.
That was, as you mentioned, the consumer protection laws, but also crowdfunding laws that we had previously to this aligned crowdfunding law had the same problems. And actually, I was working in crowdfunding before going into crypto, so we had a very similar thing as was already just mentioned. And I know that there are also projects in the EU that made a token offering that was compliant with those laws. And in certain instances, I think we need to be just very careful when certain rights, especially for consumers, could at least not be limited. So I think it's going to be a lot of, again, innovation and legal innovation when it comes to those offerings in the future, for sure.
Great. And one other item I wanted to sort of cover was, and I think this connects to completeness and the need to potentially update your white paper, is just the ongoing obligations with regards to disclosure, even following the publication of the white paper, and the implications of those points in terms of the liability and the need to make sure it's accurate, complete, et cetera. So I don't know if anybody wants to comment on what type of practices will likely be taken on by some of the issuers or even offerers on some of those disclosures in the white paper.
Well, it's really like required. If something changes, you need to update, which is also like common in European law. And if you don't do it, it basically triggers all the consequences that we have already discussed. So it's really pure liability. It's like if you start from zero and you don't make your homeworks. And so on this regard, it's something which needs to be taken into consideration. It's not that once you notify, it's finished. You have always to make clear that you need to comply with a proper way of communicating the characteristics of the project. A problem that I see is perhaps it's a bit a niche, but it could happen. We see now that there is always the willingness to decentralize the protocol, decentralize the control, and so who will care about this duty to notify the amendments of the project within the white paper? This is something which I was asking to myself, and of course here we have to basically to base ourselves on who is the offerer, and if it's a CASP, then the CASP needs to take this problem into consideration. But basically, every potential offer can be affected, and this is once you list the token, you need also to follow up with what the token is doing, what the community is doing, and so if it taken seriously and in an effective way, this could also be a reason to basically scrutinize all the tokens that you have listed in an exchange on a continuous basis. And we know that there are tokens that change their tokenomics in a way which is immense. At the beginning, a lot of tokens are mere governance tokens, and then they become something different to increase the willingness to buy them. and so it can have some repercussions, but it's more, I would say, at a compliance level from the CASPs, because the big elephant in the room, and we're going to discuss it in the next episode, is like, what is not clear is what happens if for instance, the exchange, which is authorized in Europe, sells something which is a security. Like, what happens? Is this possible or not? It's not really clarified. The response should be no, but is it a possible response given the amount of tokens that are offered by these exchanges? And I think that this is basically the same problem. Only difference is that basically we have a token that then changes nature, but the compliance measures will be the same.
I think the interesting part here is I think it's Article 18b that mentions when the operator of the exchange would like to still list the token, but there is no white paper written or issued, then they can do it themselves. And in this case, even for the in a way entity that wanted to list, or I think in this case they will be responsible if, again, the information they share is misleading. And then, of course, it's very interesting when the exchange at the same time is going to be the one interested in listing, write the white paper, check the white paper, of course, because they're listing it themselves, and then make sure that they're updating the white paper over time and checking this project and following this project. And of course, it's going to be also very interesting to understand how much information is public and how much information can they get through this specific. It could be, probably it will be the issuer, not the offerer in this case.
Anybody have anything else they want to add on that?
Maybe a quick point, again, practical, on publication on website. I mean, we have this concept in Europe related to durable medium. For example, documents, official documents, banks need to keep, information in a readable manner for 10 years. For example, in Romania, things will probably change to 5 years. But I know that, for example, durable medium in other countries like Poland, also blockchain can be a durable medium. Now, closing this parenthesis, what happens if you lose your domain? I mean, who's going to keep a sort of an account if your white paper is still online or not? Is it going to be a matter of the authority in the host country to keep this for, I don't know, 10 years, 15 years? Because if we rely solely on the issuer, after a couple of years, they might lose their domain. I mean, who will care? How can you ensure that the initial publicity is maintained in time? Because there it's written until the tokens are with the public. So let's say if you manage to get back the whole quantity of tokens, then you don't have any publication obligations anymore. But this is very unlikely. In most cases, tokens will be out there for many years or so.
So yeah, this is a very interesting point, Alexandro. What I believe, what is a practice in Germany, that there will be a copy of the white paper with the regulator's database lying, and also any modification to the white paper will be published with the regulator. I think this could be the case also for the MiCA white paper, because otherwise it's exactly how you're saying it. I mean, if someone is taking down his web page and the white paper is not any longer available, it's also very difficult for the token holder to show evidence that there was something misleading or something wrong and do that. Therefore, I think that the regulators are going to have some kind of database where they will upload the different white papers, and maybe even ESMA is going to do that.
I think we'll get to the European level database with all white papers after a while.
Great. So we're about 10 minutes over. Hopefully next week will be even better still. So thank you all. And we'll pick this up next week, and enjoy your weekends.
Bye-bye. Have a nice weekend.